Hello, everyone. My name is Seth Matus. I'm a labor and employment attorney. I mostly work for employers. I'm here with Alex Stamatoglou today. He's an attorney who works in labor and employment mostly for employees. We're going to be talking today about some different issues that are commonly faced in labor and employment law, which you will see as an employee. So the first thing that I just wanted to talk about would be just understanding how the large majority of people are classified as employees. And what I'm talking about in particular is the idea of at-will employment. What that means when you talk about an at-will employee is that you can be terminated for any reason at any time. And at the same time, you also have the right to leave your employment at any time for any reason. So there is not a need, if you're an employee, to give your employer 2 weeks. There's not a need to tell your employer why you're leaving. On the other side, what that means is that the employer doesn't need to tell you if it is letting you go. Why? Doesn't need to give you any particular time. Now, I'm going to turn over briefly to Alex so he can talk about some of the exceptions to that rule of at-will employment.
Thanks, Seth, and hello, everybody. So yes, Illinois is an at-will state, and Seth, thanks for summing it up nicely. As you mentioned, while Illinois is an at-will employment state, there are rights that protect employees in the workplace, and these rights extend to protection from various forms of discrimination and retaliation. What this means is, while again, in an at-will state, you can be fired for any reason or no reason at all. The exception to that is you cannot be fired for a protected reason. One of these reasons may be your race. One of these reasons is whether you have a disability, assuming you can still do the essential functions of your job. You cannot be fired because you're pregnant. You cannot be fired because of your sexual identity. These are just some of the protections that are in federal and state law that are exceptions to the at-will employment relationship. It's true. People can be fired or leave for any reason or no reason, but at the same time, people are afforded protections to protect them from being treated unfairly based on discrimination.
One of the other things that I often see a lot of has to do with employee handbooks. And a lot of times I'm contacted both by employers and employees wanting to know whether any particular handbook policy is something that they can really rely upon. Now, the way that works is it depends on what is in the handbook. Most of the time, when you see an employee handbook, if you look at the introduction, you will see sort of a disclaimer, and it will say that this doesn't change your at-will status. And sometimes what the handbooks will also say is we can change these policies for any or no reason at all. In those types of situations, what that means is that really you don't have any particular right under a handbook. There are a few exceptions to that. So one of them, if your employer has a vacation policy and it talks about how you're going to be accruing vacation, what happens is that you actually have a right under Illinois law to have that paid out in the way that the policy is stated. And so if the employer changes it, it might be changing how the vacation policy works in the future, but what you've already accrued and earned, that can't be forfeited. There's another thing as well in terms of expense reimbursement, which operates in somewhat of a similar way. If the employer does say that you're entitled to be paid expenses in a particular way, that's something also which is enforceable under law.
Hmm.
So Alex, do you want to chime in? Do you have anything extra on that topic?
I think you're right on, Seth. I would also add that many times when people are brought on in a new job, in a new position, in addition to being presented with an employee handbook, often they're also presented with confidentiality agreement, non-compete agreement, restrictive covenants, which limits the ability of the employees to pursue certain types of work in the event that they are to leave once the employment relationship is done. Now, Seth, you can weigh in on this, but it's good practice, I think, for employers to present that agreement separately from an employee handbook for the very reasons that you stated, Seth. That it's often an employee handbook states the disclaimer says this is not an agreement, and it goes against that very disclaimer to then include an agreement, a restrictive covenant that an employer may one day want to enforce. So often it just makes sense on the employer side to keep those agreements separate, because if they don't, then it can get messy for the employer to enforce that contract, to enforce the restrictive covenant. And being on this side of the on this side of things, if someone comes to me and says, is this an enforceable agreement? Is this an enforceable non-compete? I think that raises serious questions as to the enforceability of that agreement.
I think that's exactly right, Alex. And so certainly, any of the rules being an at-will employee can be altered. I mean, if you have employment agreements, that's the sort of thing which can make it where you're not an at-will employee. Now, say with a non-competition agreement or a restrictive covenant of that sort, usually they'll have a provision that says that, well, that you're still an at-will employee, but now you have this extra obligation. And there are certain rules, specific rules that Illinois courts have put in order to make a non-competition agreement enforceable in that case. What an employer needs to do is to make sure that the employee is given consideration, something in exchange. And either that has to be some sort of bonus or promotion, or alternatively, if an employee gets presented that right at the start of employment, the employee needs to stay employed for at least 2 years. Otherwise, under Illinois law, that non-competition agreement or non-solicitation agreement would be considered unenforceable.
Yep.
The other,
and just to, I'm sorry, so just to add that, because we're lawyers, so we
sure,
traffic in these type of situations. But basically, what that means is, if you're an employee and you're signing this agreement, you have to get something in order to sign. You're giving giving away your right to work in whatever industry you want to for a period of time, and in return you're getting, like you said, a promotion, a bonus, or you're working for at least 2 years. So just to put it in a practical context, but yeah, you're exactly right.
okay. Now, Alex, I want to kind of turn back to what you had talked about before about discrimination. Why don't you tell everyone some of the types of factors, the types of evidence that as an employee's attorney, you're looking for when one of these people walks in the door?
Sure. From my perspective, the most obvious and best evidence is when an employer, a supervisor, or a manager uses just bad language, I guess, that insults someone on the basis of the protected status, or makes reference to it. If there's a record of that, a written record, or if in lieu of that, I suppose, testimony from the employee or other witnesses that said, yes, the employer mistreated me and they discriminated against me based on my religion. And they made all these comments about how my religion is not as good as the other religions, for example. That's the kind of evidence that can work. That is actually fairly persuasive. That's what we call direct evidence. And if you can connect those comments or the evidence to the adverse action, so in this instance, an adverse action would be getting fired. If you can connect, if those two events happen closer in time, the better off your case is looking. But if they're separated by, say, several years, it's harder to make that connection between your being fired and the discriminatory intent, or what may be discriminatory intent. So that's one way that people can prove a case. Other cases is through, I think they call the indirect method, where you take, when there's an absence of that type of direct discrimination, employees can prove their cases by basically comparing their employment situation with someone who is similarly situated. So, for example, someone who has the same or similar job, but is in a different, who is not part of that protected status, and show that the other person or people were treated better. And that allows the court to infer that there's some discrimination going on, even though there's not direct evidence of, say, an employer using epithets and slurs against the employee. So, as far as from my point of view, and what makes my job easier is if an employer is really rude and terrible. Those are easier cases to prove. But even if you don't have that, although it's more challenging to prove, there are other ways to prove a discrimination case.
Yeah, I mean, in my experience, that's exactly the kind of evidence that you see in probably 95% of discrimination cases. It's either direct or indirect evidence. I think that from an employer's perspective, what I always hope for if I'm working for an employer is, like you say, the longer the period of time between making a comment and the time that someone is terminated, that's always helpful. One of the other things that I think works for employers is when it is the person who hires a person and fires a person, that can help an employer, because certainly, let's say the person who's being fired is African American, the person who hired that person, that was an obvious condition. Certainly, it's going to sort of counter any idea that there was discrimination going on if it's the same person. That's the basic concept going on. Are there exceptions to that rule? Of course, always are. But that's certainly something which I look for. And certainly also the more egregious the reason for an employee being terminated, if it is something serious, I think discrimination really will not be the sort of thing which is likely to prevail in those kind of cases. I mean, certainly an employee who steals, an employee who gets into a fight is going to have a much harder time than if, they are, just laid off. That's what I.
Exactly. Yeah. And what I agree, Seth, and what in our parlance, what the courts will look at, and the arguments that employers often use to defend their action, is that the employee was terminated for a legitimate business reason. So, like you said, if an employee is just bad at their job, that is, for a reason that has nothing to do with anything other than the fact that they're not good at their job, or there are layoffs and the layoff is handled in a non-discriminatory fashion. Those are legitimate business. Those could be legitimate business reasons. Again, I mean, can an employee then counter that defense? Yes, they can, but it's from an employee's point of view and from a plaintiff's point of view, it just makes it a little bit more challenging when, say, the employee has a spotty track record as far as performance goes.
All right.
Mhm.
Okay. Let's go on to the next topic, which is somewhat similar.
Okay.
I want to talk about the idea of reasonable accommodation.
Mm.
That's a topic that you normally see when someone happens to be disabled, but you can also see it sometimes with pregnancy, and you can actually see it sometimes with uh, religion. If someone needs time off for a holiday or would like to wear a particular type of religious attire.
Mm.
And basically, for employers, what an employer needs to consider when that happens, you shouldn't judge what's being requested. You say, oh, that's ridiculous, or, judge the person's disability, religion, whatever it might be. Instead, what you need to do as an employer is to actually engage in a dialogue with the employee and try to figure out what is something that would allow the employee to perform his or her job duties while at the same time accommodating their disability, their pregnancy, or their religion. So, for example, the classic example, if you have, say, a sight impaired employee, provide special, large size type, for instance, or special equipment. That's the sort of thing that in a lot of cases would be a reasonable accommodation. Or if someone can't work, say, on Saturdays, okay, well, you work on another day. There are caveats to that. Certainly, if an employer can show that that's not going to be reasonable for the employer, it's going to create an excessive burden, an undue burden is the term that's used, then the employer doesn't have to do that. But that's the basic way you deal with accommodation. And the other thing to keep in mind, at least from an employer's perspective, is that the employer doesn't have to give the employee the accommodation that the employee is requesting. It just needs to be a reasonable accommodation, something that takes care of what the employee is asking for, while also allowing him or her to do its job.
Yep.
Alex, do you have anything else you want to add to that?
I do. And I've just through my work, I've seen what happens when employers fail to do what's required of them under the law. So when an employee does approach an employer or supervisor with an accommodation request for a disability or an illness or a condition, what the employer should not do is ignore it, which unfortunately happens, because by ignoring it and by not engaging in that process, the employer is already opening themselves to potential liability, because that's a violation of the law. Just to not engage in that negotiation, in that interactive process. So that is, I mean, it's a technical violation of the law, and it can, depending on how the employment relationship progresses, it can eventually form into a legitimate and meritorious Americans with Disability Act claim for failure to accommodate and discrimination. And that is not something that employers want to do. I mean, I urge employers to take requests for accommodation seriously and not to just ignore them. Because I mean, I've seen it from my own, just again, from my own professional experience, what happens. And it's not good. And it's an expensive mistake to make. And everyone is better off if when these requests are made, to engage in the process, to open the dialogue with the employee, and to work out a way to accommodate the employee in a way that's reasonable for all parties.
Okay. All right, Alex, I have one more topic I just want to hit on very briefly.
Great.
It has to do with employee termination and severance agreements. And I can tell you that a lot of times for employers, I prepare them. I think that from an employer's perspective, the main point of a severance agreement would be mostly to make sure that the employee is giving up his or her legal rights in exchange for a payment of severance.
Mhm.
Employees need to understand that when you're signing a severance agreement, you no longer have the right to sue after you've signed it, except in rare circumstances. And then, of course, a lot of times with employers, there's secondary reasons why you'd want an employee to sign. I mean, certainly to have the employee acknowledge that, say, he or she isn't going to be disparaging people, or if there's any type of property that needs to come back to the employer. Those are the sorts of things that get addressed in separation agreements.
I think it goes a long way to maintaining goodwill even after the relationship is over.
Yes.
I mean, it makes the employee, how the relationship ends is just as important as how it begins, because I think it makes a big difference to have, to help the employee on their way to the next stage, so that they know that employee has a good feeling and had a positive overall experience about the relationship. I think that goes a long way.
Okay. All right. So we're going to end it here. My contact information and Alex's contact information will be right behind at the conclusion of this presentation. Thanks to everyone who's watching this. And certainly if you have questions either for an employer side or an employee side, give either one of us a call or send us an email. Thank you very much.
Thank you, everybody. Goodbye, Seth.